Hey, everybody, and welcome to Law and Society. Today, I want to talk about Donald Trump's motion in the DC Circuit Court of Appeals to stay Judge Chutkan's protective order in the criminal conspiracy case that's taking place in DC. So, if you're new to my channel, please like and subscribe, and let's dive in. So Donald Trump has made a motion to the DC Circuit Court of Appeals to put a stay on Judge Chutkan's gag order on Donald Trump and all interested parties in the DC criminal conspiracy case. Now, remember, Judge Chutkan, out of deference to the appellate process, had put a stay on her own order. But after Donald Trump came after Mark Meadows on Truth Social, Judge Chutkan lifted that order and reinstated that protective order. Firstly, it's highly unusual for a defendant to take an interlocutory appeal to the appellate court that is not the appeal for the entire case, but an issue in the case. For example, now with this stay, the substance of the appeal is governmental immunity, Donald Trump's governmental immunity. But the stay on the gag order is to check out the verity of the gag order itself. So right now, Donald Trump has moved in the DC trial court, in Judge Chutkan's court, with several motions. And Judge Chutkan hasn't ruled on a lot of these motions, but she has asked for briefs on the governmental immunity motion. But while she did that, a week before that, she put back the protective order on all interested parties. And now Donald Trump is taking just that part of that order and taking it for appeal. That gag order is taking the protective order on appeal. So it's not the substantive case. It's not the motions that he's putting during preliminary motions between the setting of the trial date and when trial is scheduled to happen, which is March 4th, 2024. It is the matter of whether Judge Chutkan can impose this gag order. And while the DC Circuit reviews this case, Donald Trump wants a stay on Judge Chutkan's gag order. He would have had that stay ongoing had he not made the attack on Mark Meadows and had Jack Smith not moved for Judge Chutkan to reinstate that order. Now, going to the appellate court. First of all, in federal jurisprudence and in most states, the trial court is given great deference in the pre-trial and trial processes. So a trial court has broad discretion over trial procedures and how to manage the trial. So that falls in to the credit of the prosecution and to Judge Chutkan's order. Again, also, in the term of policy, if the DC Circuit Court of Appeals stayed the gag order while determining the case about the gag order, it would that would in effect nullify the gag order and allow Donald Trump, for that period of time that this issue of the gag order is on appeal, it would give Donald Trump the chance to go out and target witnesses again. Mind you, 75 minutes after Judge Chutkan lifted the gag order and reinstated her, lifted the stay and reinstated her gag order, Donald Trump attacked Bill Barr. It simply wasn't specific enough to the case for it to be brought up to Judge Chutkan. I still wish that Donald Trump keeps, I still wish that Jack Smith keeps notifying the court, Judge Chutkan, of any targeting. And I'm sure that if the stay is granted by the DC Circuit Court of Appeals, that Donald Trump would start targeting witnesses again. And Jack Smith would have to plead to the DC Circuit Court of Appeals to please lift that stay while they're reviewing the case. Now, Donald Trump has vowed to appeal any order that is against him to the Supreme Court. And that I wouldn't be surprised if that applies to the issue of the gag order as well. So it's like the main case is being held up. By the way, Donald Trump has also claimed that while he appeals denial of these motions, that the case, the substantive case, should be halted in the DC District Court. So this is all really confusing, and it's all really convoluted because it is a case. There's the substantive case, then there's the issues, various pretrial motions that create various issues of law and matters of fact that the district court has to rule on, preliminary matters before you get to the substance of the trial. And that will take up time in the appellate process. And that would, if the DC Circuit Court of Appeals grants a stay on the gag order and then puts a stay on the case itself, because they are for the next 3 months reviewing the case, then it will inevitably delay the March 4th, 2024 substantive case. And, if the DC Circuit gives an order directing the Judge Chutkan to pause the trial, Judge Chutkan cannot overrule that order. Judge Chutkan is bound by the order of the DC Circuit Court of Appeals. So DC Circuit Court of Appeals has a lot of, sort of important decisions to make in the next couple of days. And I would ideally want the DC Circuit Court of Appeals to deny Donald Trump's stay while they review the case before them. And that would keep Donald Trump from targeting witnesses, and then have the hearing on the substance of the case and rule on it as expeditiously as possible on every one of the motions, not have it be the 3-week waiting period that the federal courts we've seen give when they say expedite. I hope that at this time, the courts catch up to Donald Trump and say, no, when we say expedite, we mean by the next week that we will hear a hearing. Because if Donald Trump is the one bringing the case on this interlocutory appeal in a criminal proceeding, which is really unusual, he is presumptively prepared to have the appellate argument and doesn't need any more time. Any time and time deference given should be given to prosecution to prepare for these various gag orders, these various motions and appeals. So Donald Trump wants to tie everything up and jam up the DC Circuit Court of Appeals and American jurisprudence. He wants to upend the rule of law, and he wants to say that he has absolute immunity. Now I'm switching from the gag order aspect to the absolute immunity part. There's no absolute immunity in government. And the presidential immunity that a sitting incumbent president enjoys is very different and a lot more than a former president. And we've seen this in the judgment of Trump v. Thompson, this way back when there was the January 6th committee. It feels like forever ago. It all That case gave an idea of governmental immunity protecting a former president because Donald Trump didn't bring up the issue of executive privilege or immunity of former president as the legal issue before the court. Judge Kavanaugh, in the concurrence in the court, said that that issue was still ripe to bring. And that is, I suspect, the reason why Donald Trump is vowing that he will take the case all the way up to the Supreme Court if need be, the governmental immunity part of it. Now, governmental immunity, and you have GSA v. Nixon v. USA and USA v. Nixon, two cases, and then you have Trump v. Thompson on the matters of governmental immunity, and many other cases in the circuit, in the various circuits, have said that the governmental immunity falls within the job description of that particular office. And it is not the executive branch, Article 3, executive branch's job to tell, number one, the various states and those different jurisdictions how to count their votes. And it is not up to the federal executive to go and then conspire with members of the Article 1 branch of government, members of Congress, to upend the will of the people and grab power. That is not within the purview of the executive under Article 3. That is not the president's job. The president's job, very simply put, in a very short, probably short, I think it's the shortest article in the Constitution, is to execute the laws that are legislated by Congress and to sign them into law. It is not the executive's job to interfere in election procedures in various states, nor is it the executive's job to obstruct a congressional proceeding, which is an attack on a co-branch of government. Those do not fall within the immunity because they do not fall anywhere within the job description of the federal executive under the Constitution's Article 3. So that is the substance of the governmental immunity, and that will be also litigated. And I hope that it happens in an expeditious manner, and not expeditious by saying 3 weeks, expeditious by saying next week. So let's have a DC Circuit Court of Appeals hearing next week. Let's have hearings on the motions that have been denied by Judge Chutkan within a week's time of when Donald Trump appeals them. Because Donald Trump wants to stay the case itself that is in Judge Chutkan's court with the governmental immunity argument. And he wants to stay the gag order in the DC Circuit Court of Appeals of Judge Chutkan so he can target potential witnesses on social media and his public platforms. So the work is cut out for the DC Circuit Court of Appeals. I hope that they deny this stay, they review the order, and they have hearing in a week's time, at the most a couple of weeks' time. And then I predict that the ruling will be in favor of Judge Chutkan's gag order. I believe that the ruling will be in favor of the government in denying Donald Trump governmental immunity. And I believe that there's a chance that the DC Circuit will even talk about how interlocutory appeals and preliminary matters in criminal proceedings is out of the course of how business is conducted in American jurisprudence, and how it takes away from the broad discretion that trial judges have in assessing matters of law and fact-finding in the trial procedure and in the pretrial stages of the case. So with that said, that is the substance of today's video. Thank you for being here. If you like the content, please like and subscribe to my channel. I don't see any questions. If you have any questions, please ask. And if not, then please comment, and I'll be more than happy to address it. And that reminds me that one of the topics to address that a lot of Donald Trump's people and Donald Trump himself are going on is his First Amendment rights are being restricted. Well, the narrow protective order in Judge Chutkan's court specifically talks about the case and interested parties in the case. And Judge Chutkan, in a 9-page opinion that rebukes Donald Trump's statement of his speech is being curbed, that the issue of the First Amendment would likely succeed at trial, is that it fails. It does not succeed at trial because criminal defendants do not have the full breadth of the First Amendment rights, and trial procedure and the right to due process and the right to a trial and the public's interest in the right to a fair trial demands that the broad that Judge Chutkan have the broad discretion to rein in whoever tries to go and compromise the integrity of the case and the safety of witnesses and officers of the court. So that's where I am. I don't see any questions. Thank you for being here, and I will see y'all soon.